While the nation slumbered in the early hours of dawn, something monumental transpired within the hallowed chambers of the Supreme Court, an event that would irrevocably alter the very fabric of American governance. There were no advance notices, no heated public discussions, no cameras broadcasting oral arguments to millions of concerned citizens, merely an abrupt 6-3 emergency decree that promises to impact countless lives beginning as early as next month. What makes this moment particularly alarming is the aspect that remains concealed from the public eye. This judicial pronouncement extends far beyond modifying a solitary regulation or settling a confined legal quarrel. It strikes at the core of how constitutional protections function in this republic. Whether citizens comprehend it at this moment or remain blissfully unaware, the constitutional foundation supporting their liberties underwent a seismic transformation under the cover of darkness. This transcends the typical Supreme Court announcement that dominates news cycles for a day before fading into obscurity. What unfolded represents a fundamental restructuring of authority among the judiciary, the executive office, and the citizenry themselves, across state legislative buildings, federal bureaucratic offices, and judicial chambers stretching from the nation's capital to the Pacific coastline. The established protocols governing American law were completely rewritten within a span of mere hours. The troubling reality is that the overwhelming majority of Americans remain completely oblivious to what just transpired behind closed doors. In the dead of night, the Supreme Court delivered its 6-3 emergency judgment in the case designated as Trump versus Casa, Incorporated, utilizing a mechanism known ominously as the shadow docket. This procedural avenue circumvents traditional oral presentations before the justices, eliminates the customary months of careful consideration, and forgoes comprehensive public documentation, instead producing a lightning-fast determination that instantly transforms the legal terrain upon which all future cases must navigate. The litigation at hand centered around a contentious executive directive connected to the doctrine of birthright citizenship. However, the court seized upon this particular dispute to accomplish something exponentially more consequential. It resolved a protracted internal conflict regarding judicial authority that has been silently intensifying beneath the surface for over 10 years. At the epicenter of this ruling exists a legal doctrine that the average American has never encountered in conversation, yet has unknowingly depended upon for generations: the mechanism of nationwide injunctions. The Supreme Court has now decreed that federal magistrates are permanently prohibited from issuing universal restraining orders that prevent a statute or governmental policy from being implemented throughout every corner of the entire country. While this might initially appear to constitute mere technical jurisprudence vocabulary, the ramifications are absolutely staggering in their magnitude. This solitary judicial determination fundamentally rewrites the established procedure through which constitutional challenges operate throughout America. Throughout the previous quarter century, whenever an individual or organization mounted a challenge against legislation they perceived as violating constitutional principles, a solitary federal judge possessed the capacity to provisionally halt that statute from being enforced in any location within the United States while the litigation methodically progressed through the appellate court system. A single jurist presiding in one courtroom could issue one directive, and the entire apparatus of federal governance was compelled to suspend enforcement on a national scale. This extraordinary authority found application across immigration controversies, healthcare policy battles, environmental regulatory disputes, Second Amendment litigation, employment standards conflicts, and electoral procedure challenges. A magistrate stationed in California wielded the power to freeze a governmental policy affecting Texas. Conversely, a judge in Texas could obstruct a federal regulation from taking effect in New York. That epoch has now conclusively terminated. The Supreme Court did not merely curtail this judicial power, it obliterated it entirely. According to official court documents examined in the immediate aftermath, there currently exists 68 active nationwide injunctions exerting influence over domains ranging from pharmaceutical medication availability to occupational safety standards and the administration of elections. Under this newly established legal framework, numerous of these injunctions face potential dissolution within the approaching 60 to 90-day window. as lower court judges frantically scramble to reformulate their previous orders. The temporal alignment could not possibly be more politically volatile. The nation barrels headlong into an election year fraught with monumental confrontations over immigration enforcement, healthcare accessibility, civil liberties protections, and voting regulations. This ruling has just fundamentally transformed the manner in which every single one of these contentious battles will be waged in courtrooms across America. The majority judicial opinion originated from the pen of Justice Amy Coney Barrett and garnered the concurrence of Chief Justice Roberts, alongside Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their collective reasoning establishes itself upon a straightforward yet revolutionary assertion. The Judiciary Act, enacted in 1789, never conferred upon judges the constitutional authority to extend protections to individuals who are not actually named parties within a particular lawsuit. In the majority's interpretation, a judge's proper function is to adjudicate specific controversies between specific litigants, not to function as a nationwide nullification mechanism over presidential or congressional actions. However, the most incendiary legal reasoning did not emerge from the primary opinion itself. It materialized within Justice Gorsuch's supplementary concurring opinion. He meticulously traced judicial practices from the founding era through the concluding decades of the 1800s and uncovered something truly extraordinary. American courts during that historical period did not issue injunctions extending protections to persons who were not directly participating in the litigation before them. Judges consistently declined to broaden relief beyond the actual plaintiffs physically present in their courtrooms. Justice Thomas advanced the argument even further, contending that nationwide injunctions represent a contemporary fabrication that actively encourages the practice of forum shopping, wherein advocacy organizations systematically hunt for ideologically sympathetic judges to dismantle policies they politically oppose. According to the conservative majority, that historical anomaly has now been officially terminated. The dissenting justices perceived this development through a dramatically different lens. Spearheaded by Justice Sotomayor, they issued stark warnings that eliminating courts' capacity to grant universal relief effectively empowers the executive branch to implement unconstitutional policies while individual lawsuits languish through the judicial system for years. They contended this ruling dangerously threatens to transform constitutional rights from universal guarantees into exclusive privileges accessible only to those possessing sufficient financial resources to initiate litigation. This marks the juncture where the theoretical discussion concludes, because the genuine impact of this determination is not confined to abstract legal theory. It is already manifesting in tangible ways across immigration enforcement, firearm regulations, healthcare policy, electoral procedures, and the broader economy. Within a mere 48 hours following the ruling's release, the legal landscape experienced dramatic upheaval. State attorneys general representing 18 different states filed urgent emergency motions in federal courthouses, endeavoring either to salvage existing injunctions or to immediately commence enforcement of statutes that had been suspended for years. Texas mobilized aggressively to constrict injunctions that had been obstructing immigration enforcement operations. Florida submitted emergency legal briefs targeting social media platform regulations and election administration procedures. California and New York responded with counterfilings of their own, frantically attempting to preserve nationwide prohibitions against federal policies they vehemently oppose. Operating behind closed doors, the Department of Justice orchestrated emergency strategic planning sessions involving hundreds of federal prosecutors distributed across dozens of pending cases. The White House counsel's office discreetly cautioned federal agencies to prepare operational contingencies for statutes they had assumed were blocked to suddenly become enforceable, possibly within a matter of weeks. The velocity and magnitude of this immediate reaction communicates everything observers need to understand. Legal strategists across the political spectrum characterize this as a massive transfer of power gravitating toward the executive branch and representing a catastrophic defeat for judicial checks on governmental authority. Advocacy organizations spanning both conservative and progressive ideological territories find themselves in emergency mode. Entities including the American Civil Liberties Union, the National Association for the Advancement of Colored People, and Alliance Defending Freedom had relied upon nationwide injunctions as their most formidable legal instrument. That weapon has now been confiscated from their arsenal. Prominent law firms are alerting clients that civil rights and constitutional litigation expenses could now escalate to 5 to 8 times their previous costs, because rather than filing a single consolidated lawsuit, plaintiffs may find themselves compelled to file separate litigation in dozens of separate jurisdictions. This is precisely where the ruling transitions from abstract legal doctrine to deeply personal consequences. Immigration enforcement emerges as ground zero for these transformations. There currently exist 19 separate injunctions constraining immigration and customs enforcement practices on a nationwide basis. Under the newly imposed framework, those protections may exclusively apply to specific named plaintiffs residing in specific judicial districts. Immigration enforcement protocols could now manifest in completely divergent forms depending solely upon geographic location. The identical principle applies to Second Amendment rights, healthcare service accessibility, environmental safeguards, workplace regulations, and voting statutes. Constitutional rights may now fundamentally depend upon zip codes. The nation potentially stands on the precipice of an era wherein federal law exists in written form but undergoes enforcement in wildly inconsistent patterns across the country. 50 different interpretations of the same statute, one constitution, but fragmented and unequal protection. As the political calendar advances toward the 2026 election cycle, this ruling establishes the preconditions for unprecedented legal pandemonium. Election administrators are already broadcasting warnings of a nightmarish scenario wherein voting regulations vary, not according to state statutory law, but according to the geographic boundaries of court jurisdictions. Corporate America finds itself in a state of panic as well. Corporations operating across multiple states now confront the prospect of complying with different federal regulatory requirements in different geographic regions. The banking sector, healthcare industry, technology companies, and pharmaceutical manufacturers are all issuing warnings regarding massive compliance expenditures and regulatory bewilderment. Economic analysts estimate this legal fragmentation could impose costs upon American businesses reaching into the tens of billions of dollars on an annual basis. However, this narrative extends even deeper into constitutional fundamentals. This ruling constitutes merely one component of a broader Supreme Court strategy that depends heavily upon the shadow docket mechanism, wherein high-impact determinations are rendered without complete legal briefing or comprehensive explanatory opinions. By issuing emergency directives that effectively reshape foundational law, the court is asserting dominance over lower courts in methodologies that would have been considered inconceivable merely 1 decade ago. Critics warn this cultivates a chilling effect throughout the federal judiciary, wherein judges grow hesitant to block even transparently unconstitutional governmental actions for fear of swift reversal from the Supreme Court. For civil rights protections, the implications prove profoundly disturbing. For decades spanning generations, broad injunctions served as the primary instrument deployed to dismantle systemic discrimination embedded within governmental institutions. Presently, courts may only extend protections to the limited handful of individuals who possess the resources and stamina to sue, leaving thousands of similarly situated others exposed to identical constitutional violations unless they file their own independent cases. Justice Jackson characterized this as an existential threat to the rule of law itself, cautioning that it effectively creates geographic zones wherein the Constitution functionally does not apply with equal force. The Supreme Court's 6-3 emergency ruling in Trump versus Casa Incorporated did not merely modify a legal procedure or adjust a technical rule. It fundamentally altered the very meaning of constitutional protection in America. If the right to vote, the guarantee of equal protection under law, or the assurance of due process only exists for those individuals who personally possess the financial resources to initiate litigation, then those rights begin to resemble exclusive privileges rather than universal guarantees. The nation stands at the threshold of a new era of American jurisprudence. Whether this development represents a legitimate return to constitutional originalism and judicial restraint or a dangerous fragmentation of justice creating a two-tiered system depends entirely upon one's constitutional philosophy and political perspective. However, one element remains absolutely certain and beyond dispute. The legal patchwork has arrived, and its cascading consequences will define immigration policy, electoral integrity, civil rights protections, and economic stability for years and possibly decades to come. The question now becomes whether this represents the restoration of constitutional order or the beginning of constitutional chaos. And that answer may determine the very future trajectory of the American experiment in self-governance.